Please. My Lord, I have a matter. Actually, the matter pertains to pinch fee matter. It is an anticipatory bail. But then considering the protocol I'm mentioning before your Lordship, if your Lordship places that, I should mention report number 2.
Please, sir.
So I can do that. Lordship.
Please, please, sir.
Yeah, this is your Lordship.
Yes.
Lordship, I pray for your Lordship's indulgence. Yesterday, I filed a writ petition.
Okay.
BBC 116, but the matter could not be listed for motion today. There's an urgency for a stay, the last day. Either before this another court or in court number 2.
So can it be this court probably will rise early? And
So if Lordship could give you permission, then I'll move in 2.
please. Yes.
Lordship, I have also filed a writ petition this morning. There is an extreme urgency in this case, Lordship.
Okay.
If I may be permitted.
So if it is
Okay.
okay, please. Court number 2.
This sure of. Lordship, I'd like to mention item 11, 12, 13. That's all.
So
Yes.
yes, for the respondent,
Better we come up, presentation.
Santiago.
I have no objections, my lord.
Okay, Mr. Moaimchen, Land Senior Government Advocate. Praise for listing this matter after the ensuing winter vacation, after the ensuing summer vacation, to which the Land Council for the petition of Mr. Santiago has no objection. Accordingly, the prayer is allowed. List this matter after the ensuing summer vacation. Okay.
May I please your Lordship? Lordship, I beg to mention item number 17, Lordship, in the orders.
It is an order.
Yeah, Lordship.
We will see the record and pass necessary order. Adjournment, we are seeking adjournment.
Lordship.
Okay, we'll grant, but then let us see the record, office note and pass necessary order. Okay, we'll adjourn after vacation.
Lordship, on the 22nd, Lordship. It is a consensus prayer.
You want fixed date?
Yes,
Your-
Lordship. For the, I'm for the applicant in the IA, as well as the,
So whether the other side is present. Okay, when do you want? You said 22nd?
22nd July.
No objection. Okay, Mr. Shri Rongsung, na?
Lordship.
Land Council for the applicant is okay. Land Council for the applicant. Praise for listing this matter on 22nd July, 22nd July.
Lordship.
The prayer not objected. Accordingly, list this matter on 22nd July. Okay.
Deeply obliged, Lordship.
Yes.
Any kind of stream.
You are for the petitioner?
For the petitioner.
Wait, we'll see. There is nothing, I think. You are for the petitioner. Be there, be there. Be there.
May I please lordship?
Yes,
My lord, I beg to mention item number 16. My
okay.
lord, here, yet to receive instruction, so can I not mention which that?
Worship, the additional matter pertains to vehicle occupation of the petitioner's land by last and by first lordship.
That's not urgent.
Lordship, on the last occasion,
Hmm.
on 59/5/2025, this honorable court has directed to get necessary information for interim survey of land lordship.
So,
No, I have not received any
No.
instruction.
okay, Mr.
Kiruba.
Land Council for the petitioner is present. Mr. Tibabong, Government Advocate. For the respondent number
For some number 5, 6, and 7.
5, 6, and 7. Submits that he is yet to receive instruction in this regard, and therefore pray for listing this matter after 3 weeks. Yangavat is also there. Have you received? Okay. Are you also filing affidavit? Have you filed? Okay, similar prayer has been made by Mr. Yangravati, Lane CGSC. Okay, the prayer is allowed. List this matter after 3 weeks. Okay.
Okay, much better.
For motion, item number 1.
Yes.
Oh, by this petition, I am questioning the authority and the jurisdiction of the state to issue a pata over a private land. That is a land which is not vested with the government or at the disposal of the government. Now, in this case, the pata has been issued on a private land. The impugned pata, that is at page 32. Now I have page 32.
Yes.
Now this has been issued on our private land. Now the admitted land tenure system in the state of Nagaland, as your lordship is also very well aware, is that land, ideally land does not belong to the government. It has to be acquired or it has to be donated by the people to the government to be vested with the government. Now in this regard, allow me to take the lordship to page 80. There's a standing memorandum issued by the state government at page 80.
80.
Yes, 80.
Yes.
Yes, now just the relevant next to the first paragraph. Now, due to the prevailing land tenure system in Nagaland, barring Dimapur Mosa, all other land belongs to the people and accordingly, government have to acquire / requisition land, mostly by payment of land compensation for developmental purposes. There are instances where people have also contributed land to the government for specific purposes. Now, in this memorandum, 6 categories of land are listed. In below at the bottom of the page, your lordship will see category A. This is acquired land. Once the land is acquired, your lordship is also very well aware, the land becomes vested with the government. In the next page, category B, this is a donated land. Again, once land is donated to the government, it becomes vested with the government. Category C, these are town / settlement areas under government control since pre-independence. Now, as per Article 294 of the Constitution, land automatically becomes vested with the government. The properties of the properties or lands of the Majesty, of Her Majesty, it becomes vested with the state as per Article 294. Now, category D is Dimapur Mosa. This all the government considers it as cadastral land. And category E, reserved / protected forests. Category E, F is land to be acquired. Now, these are the 5 categories of land which remains vested with the government or are at the disposal of the government. Now, at page 83, this is also another office memorandum issued by the respondent number 1, where it says the first paragraph, which is relevant to my context, is that the Assam Land and Revenue Regulations will be applicable in full in the Mosas.
You're reading paragraph?
In the first paragraph. I'll just
Okay.
read on it. instances have come to the notice of the government that during the past few years, cases of settlement and transfer of land from tribals to non-tribals have increased considerably, particularly under the Dimapur subdivision. It is apprehended that the liberal settlement and transfer of land from tribals to non-tribals will seriously jeopardize the interests of the tribal people, and it will go against the existing laws, regulations, and instructions issued from time to time. The Assam Land and Revenue Regulation 1886 is applicable in full in the case of Dimapur Mosa, and the spirit of it is to be followed in the rest of the state. Now, this is how, in the absence of a land law in the state of Nagaland, the state government follows the Assam Land and Revenue Regulations, and amongst others, based on this regulation, settlement, allotment, or patas are issued to the individuals on lands which are vested to the government or which are at the disposal of the government. Now, the contention of the petitioners is that the pata which has been issued, it is violative and ultra-vires the Assam Land and Revenue Regulations, because there is no authority or jurisdiction in the state government, or for that matter, the state supervisory authority, deputy commissioner, to issue a pata on a land. There is no jurisdictional fact in this regard. That is the contention of the petition.
What is the procedure for issuing
Yes.
pata
Very
by the
good.
department?
You also may have, can we have the Assam Land and Revenue Regulations?
Normally here, what is the procedure followed here?
Uh,
Probably the person who is seeking allotment have to apply.
Yes, normally they will file an application before the deputy commissioner or the commissioner,
Hmm.
and seeking allotment on certain, on the land which they desire, pata or allotment. And based on that, the process will be carried out.
Okay,
And subsequently, once survey and all the exercises are done, the pata or the allotment will be issued.
okay.
Now, since the statute that is prevailing in the state is the Assam Land and Revenue Regulations, allow me to take the lordship to the definition, one definition, amongst others. Section 3B. Section 3B. Now, this defines estates,
Yes.
and it is on
3B.
this, yes, 3B. Section
Yes.
3 subclause B. Estates as your lordship.
Yeah, estate. Where is?
Under the heading of definition.
Yes, definition, the
Yes.
A is there.
Now, estates. Now, in
Estate is B, it's written A.
yes, it should be.
Hmm.
Under the regulation, the settlement or a Jamaman list or pata as we call it, can be issued only in these estates. On the reading of the entire regulation, now the estates includes, this is what the text says. Estate includes.
Just a minute.
Yes.
You are reading
Section 3B,
B.
the definition of the estate.
Where is 3B? Estate includes.
Yes, estate includes.
Okay. Hmm.
Estate includes one.
Hmm.
Any land subject.
Yes.
Yes, so any land subject, either immediately or prospectively, to the payment of land revenue, or the discharge of which a separate engagement has been entered into. Number two, any land subject to the payment of or assessed with a separate amount as land revenue, although no engagement has been entered into with the government for that amount. Number three, any local area for the appropriation of the produce or products whereof a license or farm has been granted under rules made by the government under section 155, clause E or clause F. Four, any jar or island thrown up in a navigable river which under the laws enforced is at the disposal of the government. Five, any land which is for the time being entered in the Deputy Commissioner's Register of Revenue, pre-estates as a separate holding, and six, any land being the exclusive property of the government, of which the government has directed a separate entry in the registers of revenue paying and revenue free estates mentioned in Chapter 4. Now, these are the estates on which settlement or joint monies are being issued under the regulations. Now, in this regard, the Lordship may have section 155. Section 155. Now, since the reference was made to section 155, clause E and clause F, the Lordship may also have the rules that section 155E.
Yes.
Section 155 reads as the government may, in addition to the other matters for which they are empowered to the regulation to make make rules consistent with this regulation relating to the following matters. The matters are specified. E reads as the granting of licenses to prepare or collect or the farming of the right of preparing or collecting rubber, lag, and other forest produce upon land over which no person has the right of a proprietor, landholder, or settlement holder. Now, the memorandum states that in Nagaland there is no concept where there is no concept of no man's land. That memorandum is clearly and categorically specified. F reads as the granting of licenses or the farming of the right to work mines, stones, and lime quarries, salt wells, and oil wells to fish in fisheries proclaimed under Section 16 and the on board or washing operation. Now, these are the two subsections which have been referred to in 3B. Now, there's the definition of settlement. The Lordship could see that in rule 2F of the regulation.
Two,
Rule 2F. The rules under the regulations.
yes.
Yes. Rule 2F defines settlement. Settlement in these rules means the leasing of
Just a
the
minute. Rules 2F,
2F.
then reform rules 1961. No, this is one. Just a minute. Rule 8 page.
The text I have is different, so I will not be able to.
Okay, just a minute then.
The rules under the regulations, your Lordship. Yes, find it out from the text.
Rule 2.
2F.
There are some land requisition and acquisition rules.
The rules under the land and revenue regulation. Part 2.
But just a minute. No, the
Should I assist your Lordship?
yes.
That is the rules. In the next page. Lordship will see the definition of settlement. 2F.
2F.
Lordship.
Yes.
Settlement in these rules means the leasing of the land at the disposal of the government and includes the operations of survey, classification, and report preliminary to such leasing. Now, therefore, the contention being that before any settlement, allotment, or jababandi or pata is issued, the land has to be at the disposal of the government. Now, a private land is not vested with the government or at the disposal of the government, cannot be leased out for the purpose of settlement or issuance of pata. And that there is the entire crux of the matter and the contention of the petitioners. Now, this jurisdictional fact, to the extent that the land has to be at the disposal of the government for the government or the deputy commissioner to issue pata, has to exist before a pata can be issued. Now, in the context of Nagaland, as the office memorandums which I've referred to, the two office memorandums have shown, land, all other land belongs to the people or the individuals or the community, except those which have been acquired by the government or donated to the government by the people, or the pre-independence Her Majesty's land and property. Only in those lands, it is the submission of petitioners that the government can issue a settlement or a pata. Therefore, the Assam Land Regulation does not permit the state government or for that matter the deputy commissioner to issue pata blindly. The pata cannot be issued in a vacuum. It has to operate under the ambit of a statute. Now, that statute is the regulation which governs.
Now, if somebody
Yes.
applies for pata, then even if the person apply by filling up all necessary format, the deputy commissioner then have to examine whether this comes under the government or not.
Yes, it has to examine first whether the land is vested with the government. Because merely because a private land, suppose I, having a private land, want to apply for a pata. Now, will that confer jurisdiction on the deputy commissioner to issue a pata under the act?
No, so for example, if the lands are private and then for some business purpose or for some other purpose, the person wants a document of pata, say for example, for obtaining loan, etc. So then in that case, suppose the person applies, then what do?
Then, in that case, in the absence of a statute, there is nothing to help the government or the individual.
Now,
these-
then also the DC doesn't have, deputy commissioner
No.
doesn't have the power to issue.
No, it cannot. There has to be a statute to confer jurisdiction on a deputy commissioner to issue a pata.
That means you mean to say that he should refuse to issue pata?
Yes, exactly.
that area.
And in that regard, the deputy commissioner, the office of the deputy commissioner, as well as the commission, they have realized this. Now, challenging this pata, I have approached the commissioner under Rule 26. Now, there's a provision where any person aggrieved can approach the commissioner to cancel a pata, which has been issued in contravention of the regulation. Now, I filed the application. The commissioner definitely they realize it.
So the commissioner is the authority who can
Yes.
pass order.
Yes, and I filed my application under Rule 26, which has been dismissed. Now, the commissioner.
There is no other appellate authority under the rules,
No. Now,
under the act.
No, under the act, we have the commissioner. After that commissioner, we approach the High Court. In the absence of the board, revenue board.
The order passed by the commissioner can be, or the appellate authority for the order against the order passed by the commissioner is the High Court or what?
Yes.
Not under the rules.
Yes, and an application under the commissioner is not an appeal also. The rule does not provide for an appeal provision. If you also may have Rule 26.
Okay, then what next then? If the rule doesn't provide any appeal provision?
No, and a pata has been issued. Now, the only manner in which the pata can be cancelled is provided under Rule 26. There's no other provision as far as I'm concerned, to my best understanding, there's no other provision for cancellation of the pata. Except for Rule 26, if the lordship may also have that for clarity. Rule 26. Your lordship found it?
Confirmation.
Yes, subject to the general control of the state government, the commissioner shall have power to confirm all settlements and also to cancel any settlement made in contravention of these rules. Now, we have, even though it is not with me at the moment, but we have a division bench of the High Court which has clearly expounded on the jurisprudence as far as Rule 26 and saying that commissioner has a power to cancel settlement which has been issued in contravention of rules. Be that as may, your lordship, I am by this petition, I am seeking to the lordship's indulgence, the lordship's indulgence to set aside the impute pata, as well as to issue a declaration to the effect that no pata allotment or settlement can be issued on a private land which is not vested with or with the disposal of the state government. That is the prayer of the petitioners in this petition.
Okay. Yes,
Notice may be issued.
notice. Okay. Or Mr. Ali Radu, Land Council for the petitioner. Also had Miss. Her name. Inavali. Inavali is senior government advocate. For the respondent number,
123.
respondent number 1, 2, and for the state respondent number 1, 2, and 2. Why you have included this bank?
Now, the bank has been included because pursuant to the issuance of the pata, the respondent, private respondent number 4, who is the petitioner's brother, he mortgaged this pata. Subsequently, the loan was defaulted based on which sale notice was issued, and therefore, as a matter of propriety and as a matter of abundant caution, I will leave the bank.
By filing this writ petition, the petitioner challenged the jurisdiction and authority of the state government to issue allotment stroke patta over their private land. That is a land not vested with or at the disposal of the government. The case, the contention of the petitioner is that in terms of section 3B and rule 2F of the Assam Land and Revenue Regulations, settlement stroke patta can be granted only on those lands which are at the disposal of the government. Which are termed as estate as per the regulations. The estate and N, the private land or any other private land, or their private land, or any other private land would not come under the ambit of the definition estate under the regulations. Stuff. Any patta granted on the private land not coming within the ambit of the term estate, that should be within inverted comma, would be ultra vires the regulations. And ignoring this absence of jurisdictional fact, the commissioner, respondent number
2.
2, dismiss the petitioner's application filed under Rule 26 of the regulations. Being aggrieved, the petitioner challenged the you have challenged this commissioner's order also?
Yes, yes. Page 73, detail, 27 March 2024.
Challenged the order dated 27/3/2025,
Yes,
passed by the commissioner,
yes.
Nagaland, Kohima. And also praise for
Setting aside the impound
setting aside the impugned patta number,
4396,
patta number
4396.
43, patta within bracket new, bracket close. Patta number, number new 4396, plot number 3179, issued by DC Kohima allotment order number REV stroke O-N stroke 1 -2001, dated 18/7/2001. Stop. Right. Issue notice. Returnable by 4 weeks. Stop. Since Ms. Inavali, non-government advocate, accepts notice on behalf of the government respondent number, state respondent number 1, 2, and 3. No formal notice needs be issued to the said respondents. You have received enough copy?
I'll send it to them.
Okay, how about the petitioner shall furnish requisite copies to the land council, Ms. Inavali, staff. The petitioner shall also take steps upon the private respondent number 3 and 4. 4 and 5 by a registered post with AD as well as by usual process within a week from today. Stop. List this matter after.
Lordship, I have it until now.
4 weeks.
The Lordship is going to.
What interim? What interim?
The stay of the, not the pata, but the impute order passed by the commissioner, since this.
So
court is
what-
going to examine the validity of the
How it
pata.
is going to affect you now?
In case,
Hmm.
that's a better way, not because if the bank was to take any further steps. based
Pata
on
was
the
issued
order.
long back in the year 2000.
No,
one.
prima facie, I
Hmm.
believe your lordship will have seen that pata could not have been issued.
Yes, that
Now
is
the
there, but then let
commissioner
us,
has-
let,
In
let
addition
the
to that,
government-
if I may, lordship, in addition to that, the commissioner. has-
no, now we do not know because it involves with the fact also. Now, the person who obtained the pata, he might also reply, I don't know who is owner. We have no idea.
Yeah, that aspect is there, but at least the interest of justice, that is still the returnable.
No, your lordship, I have objection.
No, so here stay probably not possible. The pata was
Then-
issued
then
long
in that
back,
regard-
way back in the
that
year
regard.
2001,
That be,
some around
Then we
24,
modify
25 years back.
constitution. now the commissioner has, if your lordship may have, page 8. Sorry, sir, my apologies, page 13. The finding recorded by the commissioner must to the effect that,
Page 30.
yeah, page 30. Starting from paragraph 8. Something which was not anywhere in the records, anywhere filed by the petitioners. We have never stated that we are not disputing the ownership of the private respondent form. There is nothing in the pleadings. But the commissioner made a finding to that effect. Now, if the lordship may be so kind to at least state that finding. To the effect that we are not disputing.
No, because now you see, the pata, it was mortgaged to the bank.
Yes,
Okay, probably the original would be, or must be with the bank only.
yes, yes.
And then that will remain remain that way only.
No,
But then since you are challenging, we'll have hearing on the
It's
entire
not-
matter.
see, your lordship,
Now let the private respondent also respond.
the question of challenging the mortgage or the transaction that has happened between
Hmm.
the private respondent and the bank
Hmm.
is not the matter of adjudication before the court.
Yes.
Therefore,
Hmm.
at least to the effect that this finding may be state.
No,
that we are not
how,
stating
how
about
the
the
finding is
scope of
adversely
direction.
affecting you? The finding here, how it is adversely affecting you now?
Because there is nothing in the pleadings. Now, in case I also cannot respectfully foresee what the adversarial position of the petitioners will be, but if this finding, where's the
The
applicants?
findings, see, this can, let them first respond. Chan will pass necessary order. The entire matter will be disposed of. Let them file
Okay.
first. I think not required, it's not urgent. Okay. Okay. You, after 4 weeks, you file affidavit. Okay.
For admission, item numbers 2 to 10.
Please, Your Lordship.
Yes.
The pleadings are complete, my lord.
Mm,
So
yes.
If these matters can come up for admission hearing after the vacation.
Yes, yes. Come up for
Lordship?
admission hearing.
Yes, my lord, for admission hearing, my lord.
Okay. Heard Miss Luciano, line of counsel for the petitioner. Also heard Miss. Yes. Okay, appearing on behalf of the additional AG for the state respondent and Mr.
Worship, I am for respondent numbers 1, 2, and 3 on behalf of Santiago.
Okay, Mr. I forgot your name.
By M. Kunal.
Yes. No claim. Appearing on behalf of Mr. Santiago, line of counsel for the respondent number
1, 2, and 3.
1, 2, and 3.
Yes, sir.
Okay, then his name should be first. Okay, thereafter the state respondent. The pleadings, it is submitted that the pleadings are completed and the matter is ready for hearing. So, hearing or
If it can be for admission hearing, my lord,
Okay.
it pertains to land acquisition, my lord, so.
then it can be listed for hearing only if the pleadings are complete.
Lordship, if it can be listed for admission hearing, if you can try. my lord.
Okay. Since the parties are duly represented, let the matter be listed. But since listed for admission hearing. Okay.
Oh, that's fine.
Okay.
Regarding item 1,
Yes.
if I may be able to take steps only first by RPA, not 2 steps, only by RPA.
Only by.
RPA, registered post.
Okay, then leave that
Usual.
usual process. Leave the usual process. Okay.
Only RPA.
Okay.
For admission, item number 14.
May I please, Your Lordship?
Yes.
Chip, I'm appearing on behalf of the petitioners council this week. We have filed the affidavit in reply and the pleadings are completed. If the matter may kindly be listed after vacation for hearing.
Why? We can have hearing today itself.
Lordship, I'm appearing on behalf of the petitioners council.
Okay, just let us see. Huh? You have some idea where is the medical document where it shows that you are the daughter of the petitioner is representing the disabled person. Where you are conversion with the case.
No, Your Honor, Lordship. I was only told to appear and mention.
Or otherwise, can we dispose of? I'll just take the points and then we'll list it for order, delivering of order after vacation. Can you assist the court? Well,
Lordship, I'm appearing on behalf of my senior, so kindly, is this matter after vacation? Requires some hearing, I think, Your Lordship.
what hearing?
Here, they want, since the petitioner
He's a legal guardian only.
Yeah, yeah.
But then he is appearing on behalf of the disabled person whose father and mother expired. And then she's a disabled, unmarried, 50 plus, and daughter, because it was not probably entered in the service record because she was disabled, unable. But then unfortunately, both the father expired, and then the pension was, the mother was getting pension, mother also expired, then she is left alone. But she need to be taken care of. And then that is the only, probably the earning sources that she can survive with. That can be given. Procedure, yes. You say that there is, her name was not there, but then entire documents lost. And the deputy commissioner can issue that if final inquire. Yes, only the deputy commissioner need to inquire whether she is the legal heir of the deceased. If she is the legal heir of the deceased, if the deputy commissioner certifies, then probably, then.
Objection, because we'll have to go as per the OIN, because that's the only standing rules right now for inclusion of nominee after the death of the pensioner. That's the only
That's the only way.
only way.
Yeah, that is why if the deputy commissioner is directed to just inquire and submit report.
And there's one, if the petitioner is a resident of Manipur, so the problem will arise whether the direction will have to be.
Okay.
It has to
Then
be,
then appraise in the next. So next, what we'll do? Okay.
and the deputy commissioner only in this petition, the deputy commissioner Kohima is included, but not the petitioner is a resident of Manipur, so there will be some difficulty.
Then in that case, the deputy commissioner of the district where she is residing has to submit the report after inquiry, after verification. That should be sufficient actually. Okay. Anyway, hard miss appearing on behalf of Mr. Said Siri, Lana counsel for the petitioner. Also hard miss in our league. For the state respondent and miss.
Respondent 5 on behalf of Joshua City.
Okay, respondent number 5. Appearing on behalf of Miss. Your good name?
Sudino Su.
Appearing on behalf of Mr. Joshua Seki, and counsel for the respondent number 5.
Yes, Lord.
He is the count. Okay. The pleadings are complete. List this matter for hearing after the ensuing summer vacation. Okay.
For admission, item number 15.
Please, Your Lordship.
Yes, this is regarding deduction only.
Yes, my lord. Lordship, here, the respondents have filed their affidavits,
Yes.
but I'm yet to file my reply.
What
So
reply you
if
want to?
I may be granted some time. my
Whether
lord.
the reply,
And Lordship, here I'm led by my senior, Mr. Indy Longjam. So I have instructions to seek some more time to file reply, my lord.
deduction is not permissible otherwise.
It's fine.
It was not his fault, his or her. The petitioner is. His.
Yeah, yes, my lord, he's.
I thought of disposing this.
Lordship, my apologies, my lord. I am also not prepared today, my lord.
Okay. Anyway, next time, come prepared.
Yes, my lord.
Okay. Ms. Lozina, Land Counsel for the petitioner. Wants to affidavit, you want to file affidavit in reply?
Yes, my lord, to the state as well as the AG, my lord.
Wants to file. submits that she has received the affidavit filed by the respondents and wants to file reply to the affidavit filed by the respondents and prays for 2 weeks' time. Are they also granted, I think?
Yes, my lord.
Okay, prays for further 2 weeks' times. So, to which the learned counsel for the respondent has no objection. Prayer allowed. List this matter after 3 weeks. Okay,
Obliged, my lord.
so you file it, we'll dispose it.
Yes, my lord. Yes, my lord.
Dispose
I'll
of.
make an endeavor.
Otherwise, I'm telling you, they have deduction is not permissible.
Yes.
If there was, of course, unless there is a mistake on your part, deliberately, unless you have done deliberately,
Yes, ma'am.
unless if the government has done, some officer has done deliberately, they will punish, they will be punished.
We can dispose it of in the next day, my lord.
Yes, okay.
Obliged.
Yes.
For orders, item number 18.
Item 18, your lordship. Here I have an instruction to appear on bill responding number 1 and 2.
Okay. So for the first time,
For the first time, so I put this 4 weeks time may be given.
okay,
Filing proper.
okay. Miss,
And so long for the petition, your lordship.
Lana Counsel for the petitioner is present. So, Mr. TV Jamir, Lana Counsel, who appears on behalf of the respondent number
1 and
1 and 2. Earlier, who appeared? Somebody or first time?
for the first.
Okay, put it. Okay, and praise for some time. Miss, okay, Miss Sinali. Lana Counsel appearing on behalf of the state respondent. Also pray for some time to pray for 3 weeks' time to file affidavit in opposition. Stop. Prayer allowed. List this matter after 4 weeks.
Lordship.
Okay.
There's an interim.
Hmm?
There's an
There is
interim.
interim. Okay, the interim order pass are there, shall continue till the next date of listing. Okay. Okay. Then if you have filed Wakalat Nama,
No, your lordship.
not yet.
No.
You file in the meantime, you file so that they reflect your name in the
Lordship.
course list. Okay, the registry on receipt of the Wakalat Nama shall reflect the name of Mr. TV Jamil as the respondent for respondent, as the counsel for the respondent number 1 and 2. Okay.
For orders, item number 19.
May I bless the lordship?
Yes.
Lordship, here, the state is yet to receive instruction, so if 3 weeks time we can implement it.
Okay, Mr.
Lelam Tong Bim Chong.
Land Counsel for the petitioner is present.
Lelam Tong Pete.
Mr. Nally. Land Government Advocate. Praise for and is granted for the granted. Okay, in our government advocate. Praise for 3 weeks' time to obtain instruction and to file affidavit in opposition. The prayer is allowed. List this matter after 3 weeks. Okay.
Your bless.
Finished, huh? Okay. No.
Vincent, court number 1 खत्म हुई थी. Wow. You're one, I think.
You still are hostage, no? Right. Okay, how do you? You still are hostage. Very lovely. No.
You go, you be there, vacation, vacation, after vacation. Right. After vacation,